Hey everyone, welcome to the week before Thanksgiving. I want to do a brief little outline with judicial review and sort of this week, which is torts. Trying to think. I don't have any other real announcements. I guess in terms of class stuff, we're getting towards the end. I'll put the stuff out for next week, out on this Friday, so you can get a head start if you're leaving for next week, which will hopefully help some of you who are going out of town out. Um, yeah, I mean, otherwise, we're coming to the end. After this week, you have two pretty short weeks. One week that looks at ethics, the other that looks at some other kind of miscellaneous stuff. But yeah, so the class is definitely ending. You have one more memo, which I'll talk about shortly. You have one more exam. But yeah, so from our perspective, the end is near. Hopefully, you're wouldn't say you're enjoying the class at this point, but hopefully you can soldier on and get through it. But yeah, definitely we're getting close to the end. But I do want to spend some time talking about last week's topic and this week's topic, because they are two more of sort of our hardcore legal topics for the semester. So as far as judicial review goes, so this is last week's, which I didn't get to because I had, let's see, 50, 70, I had 280 somethings to grade. No, wait, twice from you. So I had like 310 things to grade last week. So I didn't get to the video stuff, but I want to walk through at least some of this, particularly some of the terminology. So as far as judicial review goes, you might have saw this, or if you recently had your American government class, you might have had this. The famous case at the national level is Marbury v. Madison. In terms of what you should know how to do, you should know what judicial review is. You should kind of know, under what circumstances does it come up, and some of the terminology about when it's appropriate and when it's not appropriate to hear cases. So as far as judicial review in our context, basically all it is it's the ability of a court, an administrative court, a regular court, a federal court, to review a decision made by an administrator or an employee, or something like that. Happens fairly frequently. It isn't a big deal. The idea is that there's some form of review for administrators who make a decision. And these can be serious things like environmental standards or economic rulings. They can be local things. I mean, I was listening to the radio the other day on the way to school, and they were talking about how in one of the counties around Amarillo, they basically passed a burn ban until next spring, and a bunch of ranchers were challenging it. I guess I don't really know why. Well, I suppose ranchers have reasons to burn things every now and then, but they were suing in order to evaluate that, basically claiming that it wasn't dry enough and certain conditions weren't met for the burn ban to actually be enacted. So it was ability of court to review some sort of decision made by an administrator or superior or regular employee, what have you. All 50 states have judicial review. If Louisiana has some weird stuff because they don't use common law, which is English law, they use sort of French law. But all states again have it. It's not a big deal. Pretty much every country or every court, with maybe the exception of the really low courts, particularly in Texas, where we have quite a few of those, have some sort of power of judicial review. And administrative courts, in a lot of cases, also have the power to review administrative decisions. As far as criticisms of judicial review go, I think like the biggest one traditionally is that it's not democratic. That judges are either sometimes they're elected, sometimes they're not. You don't really know much about, even when you elect a judge, you don't know a lot about who it is you're electing or what it is that they stand for. And that when you have judges who are appointed or occasionally elected, overturning decisions made by elected offices or by bureaucracy and the bureaucrats, this isn't necessarily fair. That judges are less accountable in most senses than any other employee or any other elected office holder in the federal or state system. And so when judges make really important decisions, there's kind of this uncomfortable nature of it, which is like, hey, you had a city council make a decision. All the members of the city council are elected, and then you had a judge overturn that decision. or you had a fire chief who had years and years of experience, who's subject to the city council, the mayor, whoever, they made a decision and a judge overturned it or did something about it. And so there is reason to be sort of questioning or at least, I wouldn't say hostile, but weary of judicial review. But judicial review in and of itself, the ability of a court to hear and look at an administrative case. So as far as I think judicial review in traditional courts and even administrative courts goes, I know some of you are aware of this more than others. We live in an era where everyone sues everyone all of the time. At least part of this is that even in administrative courts, and even looking at administrative decisions, in some cases it takes years in order to actually get cases through the system. And if if you're a business and you're waiting on a particular issue, or if you're a company, or if you're an individual and you're kind of in limbo, obviously that's not great. The other area is because, at least in terms of sheer volume, is that not only do we get sort of longer wait periods, we also get less precision. And that when judges make rulings, and particularly if you're in policing, you see this more often than not. It isn't always entirely clear what they want or how it is that you should proceed. It's more like, well, we'd like you to do this, we'd like you to do that, but it isn't concrete. And there's definitely more room for discretion. There's definitely more leeway. And so courts are more and more common. And again, I think if you've paid attention to anything in the last 20 or 30 years, it's just the way it is. The other issue that your book gets into a little bit, and particularly, I think for some of you, this, especially again, policing, this comes into play, is that certainly courts have involved themselves more in administrative procedures recently than in the past. You look at some of like the police shootings, for example, and your second memo got into this a little bit. There's been more influence and more sort of, I think, pressure from courts on police departments, particularly in certain areas, largely civil rights, but also some other sort of administrative areas, to interfere with things that departments previously handled internally. And I think fire has a little bit of this, although just in general it's less litigated. But certainly courts are playing more of a role. And our department chair, if you've ever had Dr. Price for a class, he talks about being a prison warden. And one of the things he experienced as a prison warden is that basically you're constantly talking to a lawyer and you're constantly in a court. And you're not in a court because you need help. You're in a court because the court's decided that they're going to play a role or meddle or influence how it is that you're operating your prison. And so that's changed a lot. I think particularly police departments have been more hostile to this than others, but certainly in all areas of government today, courts generally play a more active role. Some people like this and say it's good for courts to be proactive. Some people, particularly conservatives, tend to dislike this and say courts should mind their own business and allow agencies and administrators to take on their own tasks. But that's how judicial activism is. Is courts playing more and more of a role, getting more and more involved. So the irony is that they have less time to get involved, but they're actually getting more involved, which certainly for some is controversial and perhaps a little problematic in certain respects. So as far as actually getting an administrative procedure to court, I think it's not super easy. You have to, and we'll go through some of the criteria in a minute. Courts generally, especially state level, and if you're talking about like states like Texas, for example, or more conservative states, courts generally are pretty deferential and pretty willing to go along with administrative law and administrative decisions. So it's not completely easy, but definitely there are some caveats to that, and we're going to get to that now. So as far as what is reviewable, I think you have this discussion in your book. I mean, pretty much anything can be reviewable. We talked about the idea of egregious early on, or sort of this notion that things aren't given due process or due time. Those kind of things are typical. Your book has a full description. I'm not going to go through it. The only two things I would say is that, in fact, laws can prohibit judicial review. And so, in fact, if you're a city or if you're a county or if you're a state, you can pass a law or an ordinance that, in fact, says no judicial review for these decisions. Sometimes you'll see this, particularly in smaller counties, in order to avoid litigation. So things like, if you can't get your building permit, or you can't get your food handler's permit. Like, there are weird exceptions to this. So they can, in fact, say, hey, no judicial review. The other thing in terms of legality stuff is that on top of sort of that aspect, there can also be times where more or less things are just so broad that courts can't logically touch them. That an order or a rule or a law, an ordinance or whatever is so freaking broad that there's so much discretion that a court can't possibly interfere with the administrative rule or the administrative decision making just because there was so much leeway and all of that kind of stuff. So there are some exceptions, but definitely look at the bottom of 378 because that's where you're going to get your list, and that is where you're going to get your discussion. The stuff with removing reviewability, I don't particularly care a lot about this for our class. I think a lot of academics and a lot of courts tend not to like it because, there's always this issue, which is like if you say a court can't review something, well, what happens when somebody makes a really bad decision or really, really goofs something up? Are you really going to say, if somebody makes sort of an egregious and arbitrary or, decision, it's like, well, you can't take this to a court because an ordinance or a statute says that you can't do this. Yeah, so there are some issues with that, but again, that's a little bit outside of our pay grade for this class. So as far as actually on top of the 378 stuff, obstacles to getting things to in fact court, you have a series of terms in this case. So you have standing. So standing basically means that if you're challenging an administrative decision, you have to be affected, or in legal terms, you have to be injured by that decision. So you can't just be somebody in a community who's like, well, I don't like that, so I'm going to sue them. There has to be a direct relationship, a substantial relationship between the person doing the suing and the decision or the rule that created the need for that lawsuit. Your book has a little thing on in terms of what actually established the standing. So you have three things. So you have some sort of injury. Generally, it's non-economic, although there are weird circumstances, and there are circumstances where economic injury is enough. Two, a substantial probability that the party will be injured by a government. Okay, that's clear. If you're passing a law or an ordinance or something, or you're making a decision, there's at least a probability that you could do that. And then they have to be denied something. You can't win and say, hey, I didn't like the process. Let's change the process. You have to actually lose. So those are the three criteria. Know them, love them, whatever. They're not that difficult to get through. The other is jurisdiction. Jurisdiction in and of itself just means you're in the right court, or that a court has the ability to hear a case. The typical example of jurisdiction is like a traffic court. What does traffic court have jurisdiction over? Traffic court has jurisdiction over traffic. If you are charged with murder, you can in fact not go to a traffic court. That's not how the system works. And so sometimes specifically, if you're in Texas, for example, a city might have provisions that if you want to challenge a certain ruling, you have to do it in a local district court. You have to do it in X, Y, and Z, or you have to do it in front of X, Y, and Z agency administrator. And so jurisdiction is simply the ability of a court to hear a case, meaning you're in the right spot. That the court, the person, wherever it happens to be that you're taking this on, that they have legal authority to hear the case that you're presenting. As far as where you can sue, it's mixed, it's messy. Don't spend too much time with that. And so there's lots of issues, whether it's state, local, national, doesn't matter. Again, outside our pay grade, but there are some questions and there are some issues that get involved in this. The other sort of caveat before you actually get into judicial review in the legal system is that you basically, as on top of securing a lawyer and all that sort of stuff, you have to go through the process that the agency or the government or the department allows you to go through in order to challenge or to get through, contest a decision basically. And so, if you're a police officer and or a fire person, and you're going up for a promotion, and you're denied a promotion. Usually, for example, you'll have the ability to appeal that promotion. And it might be that you have the ability to appeal to a county board or a city council or a mayor or a committee. And then after that, you might have another step. And after that, maybe another step if you live in a big city. You have to go through the process before you get to the court. If something allows you to challenge it anywhere else other than a court, most of the time, virtually all of the time, you have to go through that process. So you don't just get to go mad and jump to a court. You do have to go through sort of the, I don't know, the nuances of the system and all of that sort of thing. Ripeness, I don't know why, I guess I have a picture of a banana for some reason. All a ripe case means is that it more or less is ready to be heard. That from the standpoint of a court, that there is a decision to be made, there's something that's interesting, that there's more or less, something going on that a court justifies or a court needs to hear. For example, if you haven't gone through the process of contesting it in front of an agency, in that case, a case isn't ripe yet. So all ripeness means is it's ready to be heard. Generally speaking, if a court says a case isn't ripe, it doesn't mean that that case will never be heard or that issue that will never be heard. It's basically like a timeout, basically saying not quite yet. We'll get to it eventually, or something else has to happen before we get to it. As far as scope of review, and I think this is the philosophical argument about this stuff. Really, how many of your decisions should be evaluated? Under what circumstances should your decisions be evaluated? Some of you, particularly, I think in both policing and fire, if you get to a certain level in your career, you're going to be making administrative decisions every day. And while you can't ever get away from the probability of a lawsuit, at some point you have to draw a line, on what kind of, and don't get me wrong, there are things that are always going to be controversial, things like promotion, in some cases hiring decisions are going to be controversial. But from that standpoint, how much should actually be up for review? Is it only controversial decisions? Is it only decisions that you make you're not an expert? Like, what conditions exist? Your book has some discussion to this. I think, and again, I know from some of your comments and from some of your discussions, some of you actually do live in a world where, you're frequently under the threat of being sued. And not only are you under the threat of being sued, even when you're not doing anything controversial, your decisions are under this threat of sort of litigation and going before lawyers. And so the question, there's no right or wrong answer. It's just really how much of this stuff, or how many of your decisions should be eligible to be reviewed. And particularly, like, progressives and liberals tend to favor more, meaning that the courts play a larger role. Conservatives tend to favor less. But even that's a little bit skewed. And so there's some sort of philosophical debate to that. You should have some ideas like, well, under what circumstances can my decisions be, evaluated? And again, that's kind of up to you. We'll actually talk about Zimmerman when we get to ethics. But no, so like the George Zimmerman thing, for example, if you remember back to the Trayvon Martin thing from a few years ago. And so Zimmerman shoots this kid, and whether or not he was justified or not, I'm not touching that with a 100-foot pole. But one of the interesting things that happened during the whole Zimmerman process was there were a lot of administrative decisions being made, particularly within the district attorney's office, but also within the local police department. And whether or not Zimmerman should have been tried, should have been convicted, should have, would have, could have, on all these different things. When you look at something like a shooting, you have a lot of people making a lot of decisions. Everything from whether to press charges to how to present a case to what issues of the case can be explored. And a lot of people after Zimmerman either was rightfully vindicated or got away with it, depending on your perspective, had called for basically a review of the local police department and of the local district attorney's office. Basically saying that they had abused their discretion. They didn't present the right evidence. They didn't do things in a certain manner that might have led to a conviction or a trial, or insert your random hypothetical. And it's like, well, is it a good thing for a court to be investigating how a lawyer, or how, in that case, a district attorney, gets involved in a case, or how a police department, evaluates a particular situation? And I think people at the time were like, of course we should do this. It's like, this guy got away with this, or again, I'm not getting into the politics of this, but there were definitely people who wanted to get more involved and get the courts involved with the whole decision-making process around the case and around, him getting off and all this sort of thing. And so this comes up, very rarely do you ever have times where it gets that serious and people get that upset and angry about it. But certainly there is some discussion, and there is something to be said about evaluating standards of judicial review and when exactly decisions should be made, and sort of figuring those sorts of things out. Evidence, I think some of you in CJ and the policing side of this are well up to date, and your sort of evidence and rules. We're not getting into that in this class. The only thing I would say is that, generally speaking, rules about evidence don't apply in administrative hearings. So we do have one rule, which is called the substantial evidence rule. Basically, it says that if, in fact, there is any evidence that supports, or substantial evidence that supports an administrative ruling, it's up to the regular court to uphold that ruling. Now, what makes the sort of issue a little bit tricky is that when you look at sort of evidence rights and other rights within the judicial process system for administrative law, there aren't a lot. And that a lot of the stuff that from a criminal law standpoint you have when you are in a normal court, you do not have all of those rights in the same respect in an administrative court. You still do have some or most of your friend or bundle rights. That there are circumstances where you certainly have the right to question evidence. You certainly have the right in some cases, or in most cases, or in 99% of cases, to question the accuser. Those kind of things, but they're not guaranteed. And your book talks about that. As far as other sort of terminologies, know your de novo review. Go through these. I'm not going to go through these one by one. De novo review, compliance type stuff. As far as I think why the judicial review and administrative law gets a little bit tricky, especially in administrative decision making, is again, three things. And we've talked about some of these, and the last one will be sort of new. Number one is there's a lot of decisions, and courts are overworked. Every court cannot, or every decision cannot be reviewed in front of a court. It's just not practical. Two, you have sort of the theoretical issue about, well, under what conditions or under what types of rules, decisions, administrative procedures, under what circumstances should courts get involved? And then the last one, which I think is sort of, I don't know if it's obvious or if it's just sort of a little bit, it's just sort of intuitive, is that a lot of the things you guys do is very specialized, and you do it on a daily basis. And this area of expertise, and part of the reason why there are lawsuits, and part of the reason why there might not be as many lawsuits as you would suspect, even though there are more of them today, is that, and again, depending on where you are in your career, this sounds a little bit strange, but at some point in your life, you'll actually be good at your job. And you'll be a good firefighter, a good city administrator, a good police officer. And, after you've been on the beat a certain period, or you've been in the firehouse for a certain period of time, that you know more than judges do, and you know more than administrators know about the kinds of things that you have to decide and the decision making process that goes into making these little things that are necessary for you to do your job. And so, well, courts can get involved, particularly when you abuse that authority or you make sort of dumb decisions. At least part of the reason why every decision doesn't wind up in court is that you do wind up being experts. Again, I think there's always sort of this tendency in administrative law to be, you're going to get sued for everything. Like, oh my gosh, the sky is falling. You're going to get sued all the time. Well, you are probably going to get sued. If you're a police officer, if you're a fire chief, you are going to get sued at some point in your life. But I think like the one thing, particularly in administrative decisions or administrative cases, that you shouldn't lose sight on is you know what you're doing. And you're good at your job. If you've been a police officer for 20 years, and don't get me wrong, there are bad police officers who have been there forever, but most of you will know what you're doing and will know more than other people. And so you shouldn't live in fear of administrative lawsuits or people questioning or going to court or to review or to challenge your decision making. But I think you always have to be aware, and at least from a practical standpoint, that you are the expert. And so a lot of times things don't wind up in court for that very specific reason. So don't lose track of that. And again, the next section is also about getting sued. So I don't want you to think like, oh my gosh, I'm going to spend the rest of my life getting sued over every decision. I'm going to have to learn all these terrible terms. I'm going to have a lawyer on speed dial. You might need some of those things, but it's not that dire, and it isn't as horrible as it might sound from time to time. Okay, second bit is torts. Torts is simply lawsuits. Torts basically means your ability to sue. Not to challenge a decision, but your ability to flat out sue somebody and sue government officials in particular. More or less, I'm going to talk about sovereign and qualified immunity. Big thing being qualified immunity today. We're also going to talk about 1983 rights, which some of you who are actively employed might be aware of as well. And then, again, terminology from this section. All a tort is it's a lawsuit. It's also a tasty pastry, but a tort is a lawsuit. The one thing that I would generally say is that rules for when and for what you can be sued over in the sort of execution of your job varies a ton. In some cases, it varies by states. In some cases, it varies by city or department. Generally speaking, the typical rule of thumb is that if you're in a conservative state or a conservative city, there are probably more restrictions on when you can be sued while doing your job, and so that's the general rule. So the more conservative state you're in, the less likely it is you are to be sued. But obviously they still happen. And so you have a state like Texas, which has conservative laws, but you can still be sued as a police officer, firefighter, administrator, all these sorts of things. So the first topic we've actually seen before is something called sovereign immunity. And so all sovereign immunity was this old English principle that basically said you can't sue the king. That the only time you can sue the king is when the king allows you to sue him. And so if we take that to American government, it basically means that you can only sue the government when the government gives you permission to sue the government, which sounds weird and kind of redundant, but over time the government has carved out exceptions where, in fact, you can sue the government. And so all sovereign immunity in its base form means is you can't sue the government because the government's unsuable. Now, in reality, there's no government in the United States that is completely sovereign in terms of their ability not to be sued. Everyone has exceptions, states, cities, counties, but in theory, that's sort of what it means. You look at some of the cases. I think like the Miller's horse case is in your book, which is probably the most famous. Basically, I don't know anything about horses, so I'm going to get this wrong. But there was an ordinance that basically said if a horse had a certain type of disease, the horse was put down. And so it's like horse gets a disease, they put down the horse. And so in the case of Miller's horse, what happened was, as it turned out, Miller's horse didn't have the disease but was put down, and so Miller was allowed to sue. And that makes sense, right? Somebody made a wrong decision. They execute. I guess they euthanized this horse, assuming that it had some sort of disease. It didn't have this disease, so Miller lost his horse for no reason, and Miller was subsequently allowed to sue for compensation. You look at towards the end of the 1800s, there's a case called Spalding. And again, your book kind of footnotes and gets into these a little bit. Spalding's really simple. Spalding had an order from the United States Congress to implement a procedure. He did this and he got sued. And basically, Spalding couldn't himself be sued because he was carrying out the will of the government. And so, as long as you're carrying out the will, that's the general rule that we're going to get into. But there are a bunch of cases that are getting into this, and don't worry about this. I think like Barr is probably the most famous. And basically Barr, depending on how you read it, and again, you don't need to worry about the sort of specifics of it. Barr in the 1950s basically said that as long as you were doing your job, or attempting to doing your job, or in good faith doing your job, you could not be sued as a government employee or as a government administrator. Now this got rolled back relatively quickly, but more or less it would mean as a police officer, firefighter, whatever, if you were doing a reasonable, good job of doing your job and you made a mistake, even if it was an egregious mistake, no one could sue you, so long as you could say it was in the duty of being a police officer, firefighter, all of these things. So Barr existed for a short period of time. It was unpopular. I think the idea that under no circumstances can you sue somebody if they're presumably, quote unquote, doing your job is a little bit extreme. But for a period of time in the U.S., that was how we perceived it. Eventually, we get the doctrine of qualified immunity. Qualified immunity is what we have so today. So those of you who work for the government will be protected by some sort of doctrine of qualified immunity. Basically, it means that as long as you're not clearly violating somebody's constitutional rights or statutory rights, and you should reasonably know that you're not doing these things or doing these things, then you're protected. So the thing that protects you as a police officer from being sued, as a firefighter from being sued, as a public official from being sued, is the doctrine of qualified immunity. So in practical terms, when can you get sued? When you clearly violate somebody's rights, and you know you are violating their rights. Hopefully that makes sense. You violate somebody's rights, whether they're statutory, constitutional, it doesn't matter. And on top of violating those rights, you actually have to know that you are violating those rights. Probably the most famous case that sets up qualified immunity is a case called Shire versus Rhodes. It involves, depending on your history knowledge, there's something during the Vietnam War called the Kent State Massacre, where a bunch of protesters of the Vietnam War were shot. And what Shire v. Rhodes was, and I wasn't alive during this, and most of you weren't alive during this, was more or less the governor of Ohio had issued some orders to the state National Guard that were a little bit intense. Like he didn't say, hey, go shoot protesters. But he did sort of set up a situation where it was probably more likely than not that there was going to be some level of escalation and some level of, violence between the protesters and the National Guard. And so after the shooting, a bunch of people tried to sue the governor of Ohio, and he had claimed at the time that he had immunity. It's like, yeah, I'm governor of Ohio. My orders are my orders. You can't sue me for making these orders, even though they led to something really bad. And what the courts did was the court said no, that the families of the people who had been shot could, in fact, sue the governor of Ohio for certain things. And the rationale is part of the governor's job to, in fact, mobilize and set some orders and do some things with the National Guard. Absolutely. On the other hand, this particular governor had, I think, and history has judged him this way, sort of over-militarized or overemphasized the need for conflict with the National Guard. As a result, was people died. And so in that case, there were certain things that he had immunity from. But the fact that his decisions in particular had led to conflict meant that people could sue him. He wasn't protected in this sort of way. If you tell the National Guard, if somebody throws a rock at you to shoot somebody, well, and that's not exactly what he did, but you're not protected if this is sort of an egregious abuse of power. And I think, again, policing standards have changed. But if somebody throws a pebble at you, you don't shoot them dead. At least hopefully not. And so there's qualified immunity. That's more or less what we see. Some of you also have what are referred to as your Section 1983 rights, which is part of the civil rights, old law, particularly if you're policing in this. What 1983 says is every person who, under color of any statute, ordinance, regulation, custom, usage, or of any state or territory, subjects or causes to be subject to any citizen of the United States or other persons within the jurisdiction of the deprivation of any rights, privileges, or immunities secured by the United States Constitution, shall be liable to the injured the party injured in an action at law, suit, equity, or blah, 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 blah. All Section 1983 means is that even if you don't violate a state or a city law, that if you're a police officer, firefighter, city administrator, if you do something that purposely violates someone else's rights, you are in fact in violation of the federal law, and you can be prosecuted for this. You do see, for example, some of the police brutality lawsuits that have been geared towards certain minority groups come under this clause. It's fairly ambiguous. But generally speaking, a lot of times when cases wind up in federal courts, particularly over gender, race being the big two in this day and age, they come from Section 1983. All Section 1983 means is that as a citizen, you, when I said protected, I should mean you as a citizen are protected, not you and your job, that you're protected from any sort of administrative decision that harms you and basically deprives you of any of your constitutional rights. Due process, any of those sorts of things. As far as the standard for discerning sort of your limited immunity, the two sort of things basically are is if you're in your job and you act reasonably and in good faith, 99% of the time you're going to be protected. It doesn't mean, I think there's always this tendency to think, which is like, if you make a mistake, you're going to get sued. Now, somebody might try and sue you, but the only way that you personally are ever going to be liable is if somebody can prove that you didn't act reasonably or that you didn't act in good faith. Reasonableness meaning that somebody else looking at your actions would say, that was crazy. Or, yeah, that was really effed up. They shouldn't have done that. Good faith meaning that, when you were carrying out your duties as a police officer, firefighter, whatever, that, you were trying to do the best of your ability. That you had taken into account, what you've learned, your training, your experience, all of these sorts of things. And you weren't purposely being reckless. You weren't purposely, endangering somebody or something like that. And so when we talk about limited or qualified immunity, when we get into this, generally, if you can demonstrate that you did something that was reasonable and that you acted in good faith, you are more likely than not going to get sued. That no one's going to get a judgment against you when it comes to doing your job and carrying out your duties. I think, again, particularly just like judicial review, there are more lawsuits in terms of suing police, fire, city administrators in the field of torts. I think the big ones over the last 30 or 40 years have involved sort of civil rights and gender rights. There have been suits in Texas over promotions and race, and they've cut both ways. We've had police and firefighters in Texas sue over being passed over because they were minority candidates. We've also saw, I think it was Austin. I apologize if I'm getting this wrong. But we also saw a lawsuit where the city of Austin was held liable for basically, not promoting whites who deserved promotion in favor of promoting lesser qualified candidates. And so it cuts both ways. But again, more of these lawsuits. But, again, just because there are more lawsuits doesn't mean you are going to lose. It might mean that it's part of your job and you might have to have some unpleasant experiences. But it's a high standard. If you're reasonable and you're acting in good faith, you're going to be fine. But there certainly are sort of more lawsuits today. The newer reasonably known standard, there's a case in your book called Wood v. Strickland, which involves some girls spiking punch at a school event. And basically what happens is, Wood v. Strickland, so the girls come in, they spike the punch at a more or less a student parent faculty event at a high school. The girls go through this process. Eventually they're expelled. One of the things that more or less the girls brought up was there are all these questions about, they had confessed at one point, then they confessed to somebody else, then the school board gets a hold of it, and basically the school board just decides they're going to suspend them or throw them out for a semester. The girls' parents wind up suing, and the end result is a weird question about due process, but basically it was like the school board didn't or shouldn't have reasonably known like all these things that had happened to the girls. Don't worry about the specifics, but you get a definition in there that your book talks about. It's a little bit of a weird case. It's kind of funny, but it's weird. And then the last couple things in terms of torts and actually suing somebody. So on top of sort of acting without good faith and unreasonably, there actually has to be a very, very clear connection between the event or the thing or the person that you're suing and the rationale for why it is that you're suing. I don't know, what would be a good example of this? Like I can't go back and sue my third grade teacher. It's like, I'm pretty sure she didn't like me because I was male. I don't really think she didn't like me because she's like, she gave me some bad grades. If I had gotten A in third grade geography, I would have went to Yale. I'd be living this great life, right? I live a good life, but I went to Harvard Law School. I'd be making millions of dollars right now. Well, I can't sue over that. There's no way you can tell that my third grade geography grade, had this massive impact on my life. And so there has to be a direct connection, meaning that, A has to equal B or lead to B. You can't just be like, well, they made this decision or they did this to me and I think it might have harmed me. It has to be direct. It has to be real. It has to kind of go through a logical person has to look at it and be like, holy crap, that person screwed up, therefore they should be sued. It can't just be like, well, they might have harmed me somehow. It has to be direct. It has to be real. Those sorts of things. As far as I think the national stuff goes, there's something called the Federal Torts Claims Act of 1946. The Federal Torts Claims Act tried to more or less, I think after the Progressive Era, after the New Deal, tried to rein in the number of lawsuits and control the types of lawsuits that happened against the federal government. Whether or not it succeeded in that is a little bit different, but there have been attempts to control the number of lawsuits against the federal government. The other sort of strange bit of this is that from the standpoint of cities, counties, and states, the 1983 stuff has played a greater role. Obviously, if you remember your history, the national civil rights movement is the 1960s, and you have the Civil Rights Act of 1964, the Voting Rights Act of 65, but a lot of things about gender and race in recent years has been at the city and state level, and even at the county level in some cases. And so more and more cities and states have faced these issues. They're facing them under a federal law, which is a little bit weird. And certainly there are cities and states that don't like this. And Dallas and Houston have both had problems getting sued under 1983 for various things that they've done, but that comes up. Last couple things. Executive immunity, pretty straightforward. Basically means that in most instances, it's very hard to sue executives. Whether or not you're talking about governor, mayor, president. Again, there are some examples, and we just talked about the guy in Ohio. but more or less executives have a very, very high threshold of being sued. And the rationale is pretty simple. It's like you can't sue Trump every time you're mad at Trump, or the entire presidency, regardless of party, how popular they would bog down. Last of the thing, and I think like this is the ending on the theoretical point. And again, a lot of you will get sued at some point in your life while doing your job. Again, they're not likely to win, but you'll still get sued. The theoretical debate is, is it too easy, too hard? Do we want people suing the government? Do we not want people suing government employees? A lot of this depends on ideology. If you're liberal and progressive, lots of people who are liberal and progressive say that we need to sue the government more. Cities, counties, states do a bad job of policing the police, if you will, or regulating, or doing things that are fundamentally unfair or unjust, and that when these things happen, you have to sue. On the other hand, conservatives look at this and say, hey, we don't buy this, but there's theoretical debates, and your book gets into that. So this is way too long, and I feel bad that I spent this much time. But go through them, learn the terms, look through these things. If you have questions, let me know. Otherwise, I don't know that I'll have a video up until after Thanksgiving break. But if I don't talk to you or post a bunch of things before then, have a good Thanksgiving. Enjoy yourselves. I'll talk to you, and you'll see more from me in the next couple of weeks. All right, have a good one, people.